Today on Bench Briefs, we're looking at a landmark Supreme Court of Canada case that touched on language, identity, and freedom of expression. Ford v. Quebec, Attorney General, decided in 1988. This case dives into the tension between protecting a minority language and respecting individual rights, a debate that's still very much alive in Canada today. So, what happened here? The story begins in Quebec, where the government passed the Charter of the French Language, often known as Bill 101. This law was designed to make French the dominant language in the province, helping to preserve Quebec's unique culture and heritage. One of the key parts of this law required that all commercial signs and public advertising be displayed exclusively in French. No English, no other languages, just French. This was a big deal for many business owners, especially those who served English-speaking customers or who simply wanted to express themselves in another language. Among those who challenged the law was a business owner named Ford. Ford and several others argued that the strict rule on signage violated their freedom of expression, a right guaranteed under the Canadian Charter of Rights and Freedoms. They claimed that by forcing them to use only French on their signs, the government was limiting how they could communicate with the public. The case made its way to the Supreme Court of Canada, where the justices had to consider two main questions. First, did Quebec's law mandating French-only signs infringe on the freedom of expression protected by the Charter? And second, if it did, could this infringement be justified under what's called the Limits Clause of the Charter? This clause allows governments to place reasonable limits on rights and freedoms if those limits can be justified in a free and democratic society. At its heart, the court had to balance two important values: the right of individuals and businesses to express themselves freely, and the government's interest in protecting and promoting the French language in Quebec. The justices recognized that commercial signs are a form of expression, so restricting the language used on signs did indeed limit freedom of expression. But the court didn't stop there. They looked at whether this limitation was justified. Quebec argued that the French-only sign rule was necessary to preserve the French language and culture, which they saw as vital to the province's identity and future. The court agreed that promoting French was an important objective. However, they found that the absolute ban on other languages was too strict. It went beyond what was necessary to achieve the goal and unfairly restricted freedom of expression. In fact, the court held that the law could require that French be markedly predominant on signs, but it couldn't prevent the use of other languages altogether. This meant that businesses could use French prominently on their signs, but also include English or other languages as long as French was clearly the main language. Why does this case matter? Ford v. Quebec is a foundational decision when it comes to language rights and freedom of expression in Canada. It set an important precedent that governments can promote minority languages, but they must do so in a way that respects constitutional rights. The decision struck a balance that acknowledges the cultural importance of language without unduly limiting individual freedoms. This case also highlights the complexity of language politics in Canada, especially in Quebec, where language is deeply tied to identity and history. The ruling influenced how language laws have been shaped since, encouraging more nuanced approaches rather than outright prohibitions. In the bigger picture, Ford v. Quebec reminds us that rights often need to be balanced against collective goals, and courts play a crucial role in finding that balance. It's a powerful example of how constitutional protections work in practice, ensuring that government actions aimed at protecting culture don't trample on fundamental freedoms. Thanks for listening to Bench Briefs. Join us next time for another deep dive into a case that shapes Canadian law and society. Until then, take care.